Hi, everyone. My name is Tania Singla, and it is my pleasure to welcome you to episode 10 of ARBinBRIEF Season 4. Today, we will be talking about a topic that concerns us all as arbitration lawyers, and that is effective advocacy in arbitration hearings. We know that there is a lot of information out there on advocacy in arbitration, but how often do you get the chance to ask arbitrators what kind of advocacy do they find helpful and effective? So we are very fortunate to have with us today two seasoned and highly experienced arbitrators who will be sharing with us their insights and experiences on effective advocacy. And they will also be answering your questions in the Q&A session that we will host right after this call. It is my pleasure to welcome our first speaker, Ms. Aarta Alkarimi, who is joining us from Dubai, and our second speaker, Ms. Laura Halonen, who is joining us from Berlin. Thank you so much for being here, and it is our pleasure to have such an international tribunal. So let's start with exploring the concept of effective advocacy in arbitration. Aarta, I will ask you my first question. Based on your experience as an arbitrator, what is your vision of effective advocacy in the context of an arbitration hearing?
Sure. Thank you for having me, and hello to everyone from sunny Dubai. I'm very happy to be here this afternoon. There are a few things that I can talk about. I think the most important thing is preparedness, having done the work and showing up totally prepared. By that, I mean advocates who perform usually very well. They come in having put the time in. It takes a lot of time, knowing your case inside and out, knowing all the exhibits, knowing your opponent's case. So they show up quite ready. The other thing that I can think about is developing some good habits. This can come through experience. You can learn it. You can work on it. One of those habits is effective listening, not just hearing, listening. So you can pick up what is it that the tribunal is actually asking you. It may not be what you've had in mind, so be prepared to give the right answer. And it's okay if you don't have the right answer. You can always reserve your right and say, that's a good question, I can come back to you. And then you can cover it in the next pleading or in your closing submissions. So that is also very important. Another thing I can talk about is keeping it simple. I think when you show up to a hearing, for most commercial cases, when you show up to a hearing, generally speaking, that's not the place to talk about complicated legal jargon and arguments that are just, you don't know where it starts and where it ends. So it needs to be precise, on point, and simple. Just speak in simple terms and present your case to the tribunal. So, one more thing that I can talk about is the culture of where you are is also very important. The legal culture, the place of arbitration also, and the culture of the tribunal, these three. If you know, for example, let's say we are in Dubai, we have two major common law seats of ADGM and the IFC, and then we have the Dubai mainland and Abu Dhabi mainland. Cultures are slightly different. Some are common law seats, so more of an adversarial style of presenting is appropriate in those seats. Dubai mainland is also influenced to some extent by Sharia law, so you can talk about certain things. You can talk about equity, right and wrong, ethics, good things that a person should have done, but they ended up breaching the contract. Those things can be effective on mainland, whereas it may not be appropriate to talk outside of those framework of what the parties agreed when you're in a common law jurisdiction. Knowing your tribunal is also very important, trying to know who these people are, having done some background research on the tribunal and their culture generally. With that, I'm going to turn it back to you.
That's a great overview of effective advocacy, Aarta. And now I'm going to turn to Laura. Laura, what comes to mind when you think about effective advocacy?
Thanks, Tania. Just picking up on that last point and expanding a little bit that Aarta mentioned, we should not forget when we plead before a tribunal that unless you're in front of a sole arbitrator, there are 3 tribunal members there. And it's important not to just plead and take into account the culture of and where they might be in their thinking of the tribunal president. The other two are there also, and their voice counts. So always we should remember to look at their body language, all three of them, listen to their questions. If you're taking them to some evidence, make sure you take the time to wait for all of them to be there.
That's great, Laura. On that note, let's take this discussion one step forward. So as an arbitrator, what kind of case presentations do you find helpful and effective, Laura? And it would be great if you can also share with us some stories on what don't you find effective in arbitration hearings.
Sure, Tania. Well, the structure is very important, as Aarta already mentioned. And the other thing I would add there is evidence. In particular, when we're talking about helpful advocacy, it is your job, I think, often as an advocate, to help the tribunal go through, evaluate, and interpret your evidence. For me personally, I'm a very visual person, so taking the visual aids that you have at your disposal to help with your advocacy is great. So that can be either as a PowerPoint or something else. For example, for structure, I like it when you have your outline on a PowerPoint, and then as you go through your arguments, you can have the headings as your main argument or the part of the case you're addressing now. It helps me to keep track, sometimes in very long pleadings, as to where we are and where we are going. It also helps with the presentation of evidence. I like it personally when someone actually puts the evidence in front of me, either as a picture on the slide, or then some advocates prefer to have it in hard copy and distribute that. All of that is fine, but just please remember, in my case, to give me the time to look at it, really just actually read it for myself, absorb it, potentially take notes, and draw at least the immediate conclusions there and then. If I can then just go to one not such a great thing, at least for me, what I sometimes see is advocates, they get lost in the game. So this becomes a game that they want to win, and the main party in that game is not actually the tribunal, who they should be focusing on, but the other side. And they end up really losing focus because they want to win on every point. And then they end up pleading and paying attention to how the other side is reacting, rather than focusing on how the tribunal is reacting. So it's important not to get lost in that, but just remember, you've got your case that you are pleading, and you are pleading it to the tribunal, not the other side.
Don't get lost in the game. That's a very helpful reminder for all of us arbitration counsel, Laura. Thank you for that. What about you, Aarta? What do you find helpful and effective in a case presentation?
Well, nowadays we have all sorts of tools that we can use to make it effective. 3D modeling, that oftentimes in complex construction cases, let's say it's used, that can be very effective. Having like a short movie of the site, for example, sometimes if it's appropriate, that could be effective. What is not very much effective, I've noticed in my experience most of the times, is when you ask questions of certain witnesses that doesn't give much to the tribunal. For example, you have a factual witness who's supposed to talk about what happened in that particular project or in that case. And then you take them further, and this has happened many times, even with lawyers that are very seasoned. You see that questions are asked from factual witnesses that are not based on the facts that they should know. It's like an appropriate question. For example, you ask a project manager, what do you think about the market? How is the real estate market in that area? These general questions that requires expertise is of no use. You lose time when you ask that. Or I could see sometimes you ask questions from expert witnesses that are not within their expertise. That's slightly different. You could potentially ask, let's say, a delay expert who is a civil engineer, a civil engineering question, although he's not testifying to that. But the weight of what he says, of course, some tribunals totally dismiss it. Some tribunals don't give much weight to it. So you should be very careful with the questions you ask. and time yourself so you don't lose time asking these things. You shouldn't be warming up yourself, let's put it that way, in the hearing. You should come absolutely fully prepared, exactly knowing what's going to happen and how you're going to handle it. So preparedness, again, going back to the first point. Another thing that I find not very helpful is showing aggression towards the witnesses, confusing the witness as a tactic. None of those things, again, for the juniors on this call, it's really not effective. Oh, one more thing that I could say is that jogging the witness's memory without taking them to the exhibits. Sometimes you can't, you have no choice. The expert is there, the witness is there to close a gap between a story that's there. But oftentimes when you have documentary evidence that backs what the witness says, or you want to basically take them to the exhibit to the extent you can and show them the document and ask questions and say, look at this sentence. This is what you said. What do you think about that? Or, don't just ask a general question out there with no reference. That I also find less helpful. But all of this then needs to be put into context because every hearing has its own life and takes its own form. So
absolutely. And I hope everyone on this call was listening very carefully because those were some great tips, Laura and Aarta. But with that note, let's move on to our next question. So as arbitration lawyers, we are often told that building a narrative through storytelling is very important. Aarta, I would ask you this. So how does a case narrative or storytelling impact the decision-making process for you as an arbitrator?
Yes, that's a very important question. It's a very good question. Narratives are important, very important, but they have to be put together carefully to support what you're trying to plead. It's not just a general narrative out there. It's not a general storytelling. It has to have an impact. Everything you say has to be useful to the tribunal. You need to be able to back it up with documentation or other kinds of evidence. That's very important. I can give you a very quick example, a real life example. A few years ago, I had a client, a very honest contractor that was unfortunately mistreated by the employer on the project. And they were so emotionally hurt by that they'd gone and prepared this massive narrative of what had happened on the project that didn't really tie into their claims. And as lawyers, we were telling them that, okay, well, this doesn't necessarily frame the breach for you. This doesn't show where causation is. And maybe, the tribunal is not really the right audience for that narrative. So I'll leave it at that. Hopefully.
Thank you for that, Aarta. I would love to hear how Laura would like to respond to that.
Adding there that something that one of my mentors, 𝗐𝗕𝗕𝗏𝗏𝗏𝗏 always used to say in my counsel days, which was that your case theory or your narrative has to cover 100% of the facts. So what this means is that do not ignore the difficult pieces of evidence. Do not ignore the difficult facts. And in particular, in this context of talking about a narrative, arbitrators, or I at least, very much like things to make sense. I'm comfortable in my decision where things make sense. But if there's something that's jarring, something that is not making sense within the context of your case theory, then that undermines the credibility of that entire case theory.
I think that's a great way to think about it, Laura, because it's so easy to get lost in the preparation process and really feel like you want to cherry pick the facts out there to represent your client's case in the best way that you can. So on that note, let's move on to another aspect of arbitration hearings, which is tribunal questions. We know that tribunal often ask questions to counsel to understand their client's position better. Laura, how can arbitration lawyers respond more effectively to the tribunal questions?
I think the first point here won't come as a surprise to anyone because it's something that has already been said a few times, and it really is the key to entire advocacy at the hearing, which is 𝗶𝗕𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏 And what I mean with that in particular in a larger case is that you don't personally have to know everyone, but your team needs to know the file inside out. And then you have to have a communication strategy within the team to make sure that the information passes to the right person and an effective answer can be given when a tribunal, throws you and asks you a surprising question. And the second point there is that the question might be surprising, and it's important to answer the question that is being posed rather than the question that you perhaps wished the tribunal had posed. So again, go to the difficult areas and confront them head on and be ready to do that. A third point I would like to add on the issue of questions is don't just listen to the questions being posed to you. Often the questions that are being posed to the other side can be very helpful in giving you a glimpse into the tribunal's thinking and potentially helping your case. So if and when you hear a question being posed to the other side, think about, should I address this? Do I already address this sufficiently in my pleading? And if you don't have that opportunity, then you should just say, actually, could I also address that?
That was a very effective response to this question, Laura. Thank you for that. Let's hear Aarta's thoughts on this.
I endorse Laura 100% on whatever she said. And this question ties very well with everything we were discussing. Preparedness, coming prepared, to some extent, knowing where questions are going to come from. A good counsel that's very much prepared can actually guess, but of course, not everyone should be doing that. You could have a feel that there are gaps, and this is where the tribunal is going to ask me a question potentially. Knowing the legal system is very important as well, because sometimes common law arbitrators may have a different style in posing questions compared to the inquisitorial style of the civil law background arbitrators, listening very effectively and carefully. And you don't need to, the last thing I want to raise, you don't need to have the answer on the spot. If you're not sure about your answer, if you think this may not necessarily respond to what the tribunal is asking you, reserve your right. Wait, go back, take a break, either come back after the break or cover it in your subsequent pleadings. You don't necessarily need to answer everything on the spot.
That's excellent perspective, Aarta. And now that we seem to be getting close to the end of our discussion before we move on to the Q&A. So I will ask both of you one final question, and that would be, if you had one piece of advice on how to be a more effective advocate for the tribunal, what would that be? And Aarta, perhaps you could go first.
Sure. The arbitration industry is a very small industry. As you become more and more senior, you'll get to know that everyone knows everybody, right? So you have to also think about your own career along the way and do things the right way. One advice that I have is always make yourself familiar with the ethical rules of the jurisdiction you're licensed to practice. Once in a while, go back, pull out the rules of ethics of your jurisdiction and review them. That way you'll know what you can actually do and not do, and how you can communicate things to your clients as well. Because sometimes clients may have expectations that you should not be fulfilling or you cannot. And it's very important to know what those are. And also know the ethical rules of the jurisdiction you're going into to work, like the UAE, for example, or the Middle East. It'll be important to familiarize yourself with that.
That's great. And what about you, Laura? What would be your one piece of advice?
Especially when you're starting out, it's really important to listen to advice and, of course, observe hearings and see how others are doing it. But ultimately, the aim has to be to come up with your own style and come up with an advocacy style that suits you and your personality and your background. Because it's a long career, it's even a long hearing often, feels like it at least. So if you adopt a style that's not natural to you, you won't be able to keep it up. And that will just make you look a little bit weird, potentially. So there are so many ways you can do this. It's important for all of us to find a way of doing it that is suitable to us.
What a great place to end our insightful discussion here today. Thank you so much, Laura and Aarta. I'm sure everyone is looking forward to the Q&A, and I invite all of you to join me using the Q&A link, the Zoom link that we have just shared in the chat. And before we go, I would just like to end with a quick note of gratitude to AAA ICDR and all of our marketing partners who make these episodes possible with their support. If you enjoyed today's discussion, please come back for our next episode on 19th March. And I look forward to seeing you all at the Q&A. Thank you so much, and I will see you soon.